Good afternoon. Thank you. Today is Wednesday, March 18th. We are in the Finance Committee. We're going to have a voting session, and I think we're going to begin with Amber on Senate Bill 389. And Amber, you have, I think, amendments to discuss?
There are a number of amendments to the bill. This was, Senate Bill 389 is an administration bill. It's the transit-oriented development bill. We discussed this yesterday. The bill was held so Senator Washington could look into some things, which did result in an amendment. So you do have another reprint in front of you. This reprint has incorporated the amendments that we did by voice, so it adds Senator Guile as a sponsor, and it adds Senator Kramer's language in, as well as the amendment from Senator Washington. So just to cover the new language that's in the reprint, if you look on page number 9, my page number 9 at the bottom right corner, written in hand, is where we see Senator Washington's offered amendment. It has to do with the off-street parking and the imposition of a minimum off-street parking. This requires that the Department of Transportation provide its decision on the findings of a parking study within 45 days, and a failure to do so would be essentially the same as MDOT concurring with the findings of the parking study. This amendment has been worked out with Senator Washington, the Department of Transportation, and the administration. Okay. And then the other amendment, just so everyone can see the language that was discussed with Senator Kramer, that is at the very last page of the bill, and it adds for the excise tax or impact fee that is imposed on a residential real estate project may be collected as a precondition to conducting a final inspection of the project, but not more than 30 days before the final date of inspection.
Thank you, Senator. Do I have a second?
Do we want to adopt the amendments or just?
Well, we'll move the amended bill. Is that okay?
Move the bill.
Move the bill as amended. Thank you, Senator. Do I have a second?
Second.
Senator Kramer seconded. All in favor to move Senate Bill 389 as amended? Thank you. 1, 2, 3, 4, 5, 6, 7 votes. Thank you, Tammy. Okay, Amber.
I'm very sorry. The next bill that you have has a 50-page reprint. It's not nearly as bad as it sounds, so I'll let you know what the bill does first, and then we can work through the reprint. Senate Bill 413 transfers all regulatory oversight of crematories and reduction facilities exclusively to the Board of Morticians and Funeral Directors, removing the Office of Cemetery Oversight's regulatory authority for crematories and reduction facilities. Even so, a person who holds a permit or registration from OCO may continue to operate under the permit or registration until it expires, and at that time, they would have to renew with the board. OCO also retains jurisdiction over complaints, and any individual cited in the complaints regarding crematories and reduction facilities that are filed with the office before the effective date of this bill, which is July 1, 2026. Senate bill, after transferring the oversight for crematories, this bill does a handful of other things, including authorizing additional grounds for removing a board member from the Board of Morticians and Funeral Directors, establishes that a quorum is a majority of currently appointed members and that the board can take action with a vote of a majority of the quorum. All right, so working through here, these are amendments that were worked out with the board and stakeholders. We have addressed all of the unfavorable testimony from the stakeholders, and the board is also in favor of the bill in its current posture as amended. So the first 20 pages or so of the reprint don't have that much going on in them. There's all of the business regulations article, and it's just really removing references to crematories and reduction facilities from that article. And then there's also an amendment you'll see throughout. The bill as introduced would have renamed the board, the State Board of Morticians, Funeral Directors, and Crematories, due to some costs that the board might experience from having the board renamed. We've struck that change, and they will continue to just be State Board of Morticians and Funeral Directors, as they have been regulating the majority of crematories for many years now. At page 20 then is where the health occupations article begins and where some of the amendments start to take place. So at page 21 and 22, engage in the operation of a crematory and engage in the operation of reduction facility. Both definitions have been clarified, that they include providing burial goods and selling pre-need goods, or they're parallel clarifications for the definition. Next is going to be at page 25. This was an important amendment to everyone. Registered crematory operators and registered reduction operators are not qualified or authorized to do pre-need contracts. So that reference to them has been struck from the bill so that they don't get that authorization. Page 28, there's some language reinstated. We're striking some brackets and adding in some brackets to reinstate language that was inadvertently removed from the bill initially. Page 31, there's a number of amendments to what an applicant needs to do for a registration. These amendments were requested by the board and offered by the chair. And it's really just altering these requirements to more closely mirror current practice and what is in COMAR right now. So this language is directly pulled from the board's regulations for what crematory must do, an applicant must do to register as a crematory or reduction operator. No new requirements are being established for to register for that. On pages 32 to 33, there were very detailed application requirements included in the business regulations article that do not model how the board operates. They already have an application that they use for crematories. So this is just striking those very detailed application requirements that are not generally codified in the health occupations article. All right. Page 34, this was language that was not in the business regulations article and arguably probably should have been, but it's just language regarding what to do if a registration lapses and how the board must go about reinstating that for an applicant. And it also models current statute for other credentials the board issues. Page 36, you'll see two subsections being struck. These are more enforcement-related provisions. They're struck here, and they're going to be moved to the enforcement subtitle on page 55 of the bill. So these do come back. On page 37, the board requested, and the chair is offering an amendment to increase the maximum fine amounts for violations. These violation amounts haven't been changed in over a decade, and there have also been issues with crematories that we know we've heard, the committee heard testimony about, so increasing this can help to increase deterrence for those activities is the hope. All right, page 38 and 39, both of them strike language that does not conform with the current board practice and operations or would have given a new authorization to operators that they don't currently have under the board. So that was language the board asked to be struck from the bill. And then at page 40, there's an old requirement for the board to give its annual report to the Office of Cemetery Oversight. Since they no longer have an overlapping jurisdiction, that requirement has been struck. At pages 41 through 49, we have a parallel subtitle. Has to do with issuing permits. And permits are issued to corporations, limited liability companies, partnerships, those sorts of crematory operations, not necessarily to an individual. But I'm explaining that only to note that the bill makes parallel changes in the permit subtitle that I've just explained for the registration subtitle. At page 42, I do want to note, there was a lot of discussion about what it meant to be in good financial standing. So this changes and establishes in the code the current process that the board uses for entities to show good financial standing, which is just the certificate of status from SSTAT that they have to provide. All right. And then next is at page 49. There's one place where the office is just being changed to board to correct it. And then from pages 49 to 51, you see a whole section being struck from the bill. That all has to do with pre-need contracts. And as I indicated earlier, crematory operators and reduction facility operators have not been authorized in the past to do pre-need contracts. They do not have the training to do that. So all that has been struck from the bill, and there is no authorization for them to do pre-need contracts in the bill. And then finally, at page 55, there's a new section 7510, and this provides explicit authority to request injunctions and restraining orders against someone that is charged with a violation. This was also an issue that came up last year with the crematory issue and not being able to enjoin their practice. So this gives them that authority to request a court to do it. And at page 56, section 4 creates a new pen for an investigator at the board. This was left off of the bill as introduced, but it was intended to be in the bill as introduced. And at section 5, after meeting with stakeholders, myself and counsel from health, we learned that most of the stakeholders' concerns about the bill really had to do with concerns about definitions in current law and regulations in current law. So this section 5 requires the board to convene a working group with stakeholders to look at the statutes and regulations under Title VII of the Health Occupations article, and to report back to the Finance Committee and the House Health Committee by December 31 on any recommendations they'd like to have made, changes they'd like to have made to the industry. And the last amendment changes the effective date from October 1 to July 1 to align with the fiscal year.
Amber, thank you. I know this was a lot more work than the way we started out. Where in the bill does it talk about the majority of appointed board members?
Sure.
While you're looking for the benefit of the committee, there was a problem with, they could not get enough board members, and the current regulation said they have to have a majority of the spots on the board, and yet you were missing board members, there were vacancies, and so they never could really get a majority to do anything when they had companies that were not operating as they should. And so the bill changes it to the majority of appointed board members. I just want to make sure it got in there.
Yeah, it was definitely in the bill as introduced, and it should be here. I just, in the 55 pages, looking for exactly where it's at. I'm sorry, Madam Chair. Let me look at the bill as introduced. The reprint is harder to find it. Okay, so it should be at bill page 27. 7204. Oh, yeah, it's
Found
right
it,
there.
Line 24, an action may be taken by a simple majority vote of the quorum. Okay.
And then up above, it says a majority of the then serving appointed members of the board is a quorum.
Okay. Any questions? Can I have a motion?
Do I have to take it to the floor if I do favorable?
No, I'll probably take it to the floor. You in favor? Senator Mouse? And Senator Lamb.
Also take a moment to recognize all the work the council put into that. I would agree.
Thank you.
Yeah, she did a great job.
I've been clapped for.
It just kept growing. I think the board was using the opportunity to try to address everything that they, and they're still gonna go back and do some. Yeah, well, there's still more, though. There's more
There's still
definitions.
more. That is why the working group, and the board, everyone was in favor of the working group. The board was in favor of convening that, just to be clear.
So, can I, we have a motion and a second. Can we take a vote? Everybody in favor? Anybody opposed? Unanimous vote. Thank you. That's 10. Thank you. Thank you very much, Amber. We started this like as soon as session ended last year.
Did. We worked on it for almost a year. Okay, the next on your list is Senate Bill 714. It's much shorter, and there is no reprint. Senate Bill 715 is a local bill that exempts mobile food service facilities and semi-permanent food service facilities located in Washington County from the requirement to have a convenient toilet and lavatory available to the public. There are no amendments, there is no physical impact, there was no opposition at the committee hearing, and there is a letter of support from the Washington County delegation. And
I
that's
see
the bill.
Senator Moss is shaking his head. He's going to be the motion. I need a second for favorable. Motion.
Washington.
All in favor of Senate Bill 714? You can enjoy a picnic table at your local produce stand or ice cream store or snowball stand. Thank you. Hendrick Rosino,
And my last one for this afternoon is Senate Bill 881. Senate Bill 881 establishes a regulatory framework for businesses that engage in commercial financing transactions. Specifically, the bill establishes requirements related to disclosures, annual percentage rate calculations, repayment terms, and other related items, as well as the extension of special offers. The Office of Financial Regulation within Maryland Labor must adopt regulations to implement the bill. There are several amendments proposed by the Office of Financial Regulation and offered by the bill sponsor. And generally, what the amendments do is, beyond setting up the regulatory framework, they also establish a new licensure type and a new licensing structure, which will then be used to fund the regulatory efforts. So at the beginning, you'll just see some renumbering. They're moving all of the first part of the bill from financial institutions to commercial law, to the commercial law article, but generally retaining the same language, except the term provider has been struck from the bill, and the term person there's been a definition added for that, as well as for the commercial financing transaction and a definition for the Commissioner of Financial Regulation. At page 4, there's a technical amendment that just rephrases the words. On page 9, this requires that the opt-in method that is established in the bill for calculating the projected sales volume of a recipient using either the historical method or the opt-in method. So the opt-in method, starting January 1, 2028, rather than immediately, is a change made to the bill. And then lastly, at the end of the bill is where the license, basically after the bill ends, as introduced, there's a whole new section that's being added. Two sections to the commercial law article, which authorizes the state's attorney or the attorney general to prosecute and provides the penalty for a knowing violation of the article. And then in the financial institutions article is all of the additions for the new licensure type. Most of what's added on pages 19 through 20 are current law definitions that have just been pulled in. But then as you get to the new subtitle 14-101, this is the new license for commercial financing. So a number of the terms that were added at the beginning are redefined again in this article. As of January 1, 2027, a person must start being licensed to provide commercial financing in the state. This bill sets a new simplified licensing regime using the NMLS to track commercial financing entities. So that's what these next provisions here at page 23 and 14-204 are setting up. In all of those requirements. At 14-207 just gives basic licensure, expiration, renewal information. Um, 14-208, 14-209 add more NMLS regulations for their license type. 14-210 establishes the reasons that the commissioner may suspend or revoke a license. 14-11 establishes a process for licensure denial and adds in again that a state's attorney or attorney general can enforce this and what a violation, what the penalty for a violation is. These generally align the licensing standard for align with licensing standards for OFR for their current license types. And that is it.
Senator Mouse has a question.
Thanks, Madam Chair. I'll be quick. The captive finance issue that was brought up in the hearing, how was that addressed? The captive financing where, you buy the equipment and,
I don't think this bill addresses captive financing.
I saw where the Asphalt Association was unfavorable. And so they buy their equipment, which is expensive equipment.
Oh, for that, okay, I know what you're saying
Did
now.
was that?
Asset-based equipment.
Yeah.
Yeah.
Is that addressed in the amendments?
No.
Okay.
The amendments generally just set up a licensure type.
Okay.
They
Thank
do
you.
not change the rest of the regulations. The rest of the regulations are the same as the committee has passed for the past 4 years.
Senator Kramer, did the asset-based, were they in favor in prior years? I don't remember the testimony on that. The asset-based equipment leases, were they in favor of the bill in prior years?
I don't recall. I just know that the bill is the same bill that we have passed in prior years. I don't recall who may have had an objection or not. Look, once again, the industry originally came in and said, don't piecemeal, don't piecemeal, don't piecemeal. So this bill was changed completely to reflect exactly what New York and California did so that it was not piecemeal. And now the industry's coming in and looking to make it piecemeal. And I would ask that we not do that, that we honor the will of those who originally said, don't make it piecemeal. And the two largest economies in the country have the exact language that we have. And it has functioned just as envisioned. And because they've actually now not only passed it, had it upheld in the courts, had it upheld in the appellate courts, put it into operation, and the industry is thriving just fine in those two largest economies in the nation.
Any other questions?
And I would move the bill as amended favorably, Madam Chair.
Who has a second for the bill? Senator Hayes. All in favor of Senate Bill 881? Okay, let's call the roll. Tammy, please.
Senate Bill 881, favorable with amendment. Vice Chair Hayes.
Aye.
Yes. Senator Kramer.
Yes.
Yes. Senator Reedy.
Pass.
Pass. Senator Mounts. No. No. Senator Jackson. Yes. Senator Washington. Yes. Senator Guile.
Yes.
Yes.
I think so.
Senator Lamb. Yes. Senator Hershey.
Businesses wanted it.
Yes. Senator
For the
Reed.
small businesses, the mom and pops.
Senator Reedy.
Yeah.
Yes. Madam Chair.
Yes.
Yes. 9-1, the bill passes.
Up next on the list is Senate Bill 493, which, as amended and shown in the reprint before you, requires a nursing facility to provide written notice of an involuntary transfer or discharge to a resident at least 30 days before the transfer or discharge, regardless of how long the resident has been in the facility. So current law exempts from that 30-day notice requirement any resident who has lived in the facility for less than 30 days. The bill also specifies that a resident of a nursing facility may not be involuntarily transferred or discharged to a location other than the location identified in the specified notice, or before the receiving facility, if they're being transferred to another assisted living or nursing facility, before that receiving facility has confirmed the transfer. Finally, the bill updates the required contents of the notice and adds requirements related to a new notice issued after changes are made to the involuntary transfer or discharge plan. So the amendments alter the names and information related to entities who may provide assistance to residents and that are listed in the required notice. You can see that on page 4 of the reprint. The amendments further establish specific requirements for the content and timing of a new notice reflecting changes to an involuntary transfer or discharge plan, including requirements related to advising the recipient of the notice when they have the right to appeal. So there is no fiscal impact, and I would otherwise just advise the committee that these are a compromise set of amendments that were worked out by the sponsor of the bill in the House with Lifespan, Maryland Legal Aid, and other stakeholders, and the long-term care ombudsman, who is the primary advocate behind the bill, supports these amendments. It is not passed second reading yet, no.
Do I have a motion for Senate Bill 493 as amended? Senator Guile, is there a second? Senator Mounts? All in favor of Senate Bill 493? Thank you.
Up next is Senate Bill 778, which as amended and shown in the reprint, establishes and authorizes the Board of Pharmacy to issue a clinical research pharmacy permit. And so the permit may be issued to a pharmacy that meets 5 qualifications: exclusively compounds, dispenses, or distributes drugs as part of scientific research conducted under specified protocols. 2, compounds, dispenses, or distributes pharmaceuticals solely incident to the research being conducted. 3, is not open to the general public for retail pharmacy services. 4, complies with specified security and storage protocols. And then finally, 5, satisfies any other board requirements. So the Board of Pharmacy must adopt regulations for clinical research pharmacies, and the bill also specifies, it also specifically authorizes a healthcare provider licensed under other sections of the Health Occupations article to hold an ownership interest in a clinical research pharmacy. So the amendments which were requested by the boards of physicians and pharmacy and offered here by Senator Lamb in coordination with the bill sponsor, Senator Feldman, strike provisions related to the definition of practice medicine completely from the bill. That's beginning on page 5 at the request of the Board of Physicians. Adds language clarifying that a holder of a permit may be investigated by the applicable board for any violation of the Health Occupations article. This was also at the request of the Board of Physicians. And then the amendments further specify that a healthcare provider with an ownership interest may not serve as a clinical investigator for a protocol conducted by the clinical research pharmacy, and then prohibits the owner from interfering with the pharmacist's ability to exercise their professional judgment. That was requested by the Board of Pharmacy. So there is no fiscal impact, and with the amendments, there is no opposition.
Reading the opposition. Senator Lamb?
Yeah, well, thank you, Senator Hershey. But yes, we had extensive meetings about this bill with both Senator Feldman, Senators Delegate Solomon, who's a House sponsor, with there's a company that's locally here in Maryland, Uncommon Cures, to talk about some of these issues as well. It's a very complicated issue. It requires a lot of time to sort this out. But I think, we've gotten to a point where, folks, the stakeholders are happy with everything. So,
Is that a motion favorable?
yes.
Second. Senator Guile. All in favor of Senate Bill 778? Unanimous. Floor leader, Senator.
No questions. You do that a Bitcoin. Or blockchain.
Senate Bill 892, as amended and shown in the reprint, requires most health occupations boards to grant at least 2 hours of continuing education credit for every hour of continuing education on menopause and menopause-associated symptoms. So the bill alters the membership of the Advisory Council on Health and Wellness, adding the executive director of the Maryland Commission for Women and a representative with expertise in perimenopausal, menopausal, and postmenopausal evaluation and treatment to the group. Finally, the bill requires carriers to provide coverage related to menopause and menopause-associated symptoms as determined by a treating healthcare provider. So the amendments strike provisions related to continuing education credits in the bill as introduced and substitute the continuing education provisions that I just described. That's on page 4. The amendments further strike a study to be conducted by the Maryland Healthcare Commission that was previously on what are hand-numbered pages 5 and 6, and then finally adds the provisions that I described related to required coverage. That's on page 6. So I'll say that as amended, the bill is identical to House Bill 1365, which is not the cross-file of this bill, but is instead a bill sponsored by the Speaker of the House, which passed out of the Health Committee in the House with a unanimous vote. These amendments are offered by Senator Guile, the sponsor of Senate Bill 892.
Sure would, Madam Chair.
And Senator Reedy, second.
I was gonna ask if we have a definition here for. Woman, but I decided.
All in favor of Senate Bill? All in favor of Senate Bill 892? Unanimous vote.
Okay, Senate Bill 417 is the first one, and that prohibits employers and their agents, representatives, and designees from taking or threatening to take specific adverse actions against an employee or refusing to hire an applicant for employment because the employee or applicant declines to attend, participate in, or listen to communications in an employer-sponsored meeting regarding the employer's opinion on religious or political matters as defined by the bill. There are no amendments.
Senator Reedy.
I had a question, and I'm pulling the bill up now. I thought there was gonna be a reprint, but there's not because there's no amendments. I had a question that came to me about local governments. And are they captured by the bill?
So currently, the bill as drafted would apply to state or local governments. They are exempt from certain provisions of the bill. For example, a governmental unit holding a new employee orientation, the bill would not apply to. And I think certain communications that a governmental agency could make, such, for example, if they're it's on page 4, it says a governmental unit communicating its employees information related to a policy of the employer or law that the employer is responsible for administering. So I think they've kind of contemplated some of the issues with
Well,
that.
I guess my question is, if it does involve local governments, you could have a mandatory meeting where all sorts of things that could fall under, some of these are very broad. The determination, I agree we don't want private employers saying you have to come to a meeting to talk about how we're organizing the local Democratic or Republican Party or whatever. But I don't understand. I don't quite understand. Okay. I'm just confused, making sure we're tight enough. So we think we're tight enough in the definition, we're not going to capture anything?
Well, to clarify your question, yes, they are included in the bill, yes. There are the exceptions in there, and I guess that's more a policy decision if those are
Okay.
sufficient to capture.
Okay.
Do I have a motion? Thank you. Senator Lamb, Senator Kramer. Should we call roll? Let's call the roll, please, Kenny. Sure.
Senate Bill, what?
We just lost 2 votes.
Sorry.
We ready? Or should I wait?
You can call the roll.
Okay. Senate Bill 417, favorable. Vice Chair Hayes. Vice Chair Hayes.
Huh?
Yes.
Yeah.
Senator Kramer.
Yes.
Yes. Senator Reedy. No. Senator Mounts.
No.
No. Senator Jackson. Yes. Senator Guile. Yes. Senator Lamb. Yes. Senator Hershey. No. Madam Chair.
Yes.
Yes. 6-3, the bill passes.
The next bill is Senate Bill 435, which, as amended, establishes the methadomazine and xylazine as a Schedule III controlled dangerous substance under the Maryland Controlled Dangerous Substance Act. There are 2 amendments. Amendment 1 is technical, and Amendment 2 strikes the bill and amends it as specified.
That's it?
Yeah, I think the only objection at the hearing was from the vets, and it does sound like they are okay with this bill. As amended, it passed in the House. As amended.
Objection to that.
Oh, I did get emailed from,
Yeah, this has been significantly altered. I guess the House made some changes, and it basically guts the entire bill and makes them Schedule 3, which is a significant change from how this bill came in. You know, and imposes criminal penalties on the use of these. This is a big change. I have heard from other stakeholders that I think may have some concerns. You know, things like the Baltimore Harm Reduction folks, the National Academy of Addiction and Disease. You know, I think the way this has been completely redrafted, which I know is aligned with the House version now, I think it's worthwhile just reaching out to some of the stakeholders just to make sure that they're okay with how this has been redone.
So you asking to hold the bill, Senator Lane?
Yes.
Thank you. All right, now we're on Senate Bill 608. I think there's going to be some amendments drafted for 608. That's the one we were talking about, the pharmaceutical gene testing, remember?
Yeah.
Taking out some of the,
Are we holding that, or?
yeah. we're gonna-
Okay.
Can you make a motion to hold 608 down?
Make a motion to hold Senate Bill 608
For the purposes of amendments.
for the purpose of amendment. I'll restate the motion to hold Senate Bill 608 for the purposes of amendment.
Thank you. I don't see any objection. Okay. Senate Bill 623.
Okay, so for Senate Bill 623, you have a whole reprint, and then you have a portion of a reprint that reflects an amendment that I received earlier this morning from Senator Washington. So I guess if you want to walk through the changes, because there were a few changes made to the reprint following the discussion yesterday, and those I marked with a star next to them. So on page 2 of the reprint, there was language added that specified that this section would apply in a jurisdiction in which the local licensing board has adopted regulations to authorize the issuance of a local alcoholic beverage license to a tobacconist to sell alcoholic beverages. I guess there was some confusion about whether this would automatically allow local licensing boards to adopt these, if they would have to come back in legislation, if it would defer to a local government. I know Senator Kramer was asking about, so this would clarify that they could adopt their own regulations without going through the legislature, but these would only apply if they did. So if a county did not want to authorize these licenses, if they don't adopt any regulations, then they don't have to issue any licenses.
So this different than yesterday, which I'm just flipping back and forth between, would mean that a local jurisdiction does not have to come back to the General Assembly to be able to have this authority for their local licensing board?
I believe so. I hope that's what that means. Honestly, the language that precedes that in Section A, we have had some debate about item 1, what that even means, if they do have to come back, if they don't. I'm hoping that 2 clarifies that they don't have to come back, that they can just adopt those regulations on their own and do that in their own local process.
Would the other choice be that they would develop regulations and members of the delegation would have to hear it and write a letter of support like we do for any other liquor bill board?
Yeah, I mean, that would be,
I think requiring the local jurisdiction to adopt regulations and then come back for a vote on their regulations might move towards a legislative veto, because you've already enabled them to do it.
Well, that's what I'm saying, change it so that we're not enabling them, that they're gonna have to come in with regulation.
Well, you could say that they would have to put in a bill to be added.
Right.
You could say that statute has to specifically authorize this type.
I think maybe Senator Washington can speak for himself, but isn't that what you were asking yesterday about? The county would have to develop regulation and it would come back to us, just like it does for almost any other liquor bill that we pass. I mean,
I don't think mine said come back. Mine said, well, my amendment says they have to promulgate regulations and develop regulations.
Yeah, his works in concert with what was in here about them applying regulations. He was just specifying what those regulations should entail.
Correct, yeah.
Okay. Senator
So-
Lamb, did you want?
I'm, I guess, still a little confused. So this amendment would allow a local jurisdiction to, the local licensing board to be able to designate these PCL licenses without having to come back to the General Assembly for,
Yeah, I believe that is the intent of that amendment, is that as this will be enacted, and then a local licensing board can either not adopt anything, in which case, they wouldn't be issuing these licenses, or they could adopt regulations and give out licenses as long as those are consistent with the section.
okay. I mean,
Like
I
the
guess.
delivery
Regulations,
permits.
They don't issue any licenses in their county.
Yeah.
I mean, that could be a choice that they don't choose to have.
I think we would have to clarify that the rules in here would still apply to the converted licenses, but then they wouldn't be issuing any new licenses, yeah.
I mean, I guess I still have some concern about, so this would be handled differently than alcohol, where the local liquor board has only authorities designated and granted by the General Assembly with the support of the local delegation. This would allow these licenses to be given out regardless of whether the delegation has supported it or not, and whether it's come back through the General Assembly for delegation support and whatnot, right?
Yeah, the local liquor board
So
would.
what we support, I'm trying to think of some of our bills, we've supported expansion, like adding liquor to beauticians and barbers, but we don't set the regulation, we just say, we passed a bill that says, yes, you can serve beer and wine in
Correct.
beauty shops.
But we
don't-
still pass the bill that says yes,
but then they create the regulation.
right?
So that's what we're
this-
saying here is, we're passing the bill that says, yes, a county can have alcohol in a premium cigar store, but they have to create the regulation that goes with it.
But we're saying yes to every single county across the state.
If they want to. If they don't
adopt
develop regulation,
regulations.
then they don't do it.
Okay, but it bypasses what you would ordinarily have as the first step for alcohol. Like we, as a body, passed to allow barbershops to have, in certain, said county to have the ability to do that. And then the regulations are obviously developed by the local liquor
Right.
board.
So why is
But-
this different?
Because we're, by this, just blanketing every county to say that they can have these licenses, even if,
Just
you
your
know,
own regulations, but you don't have to get approved
Right,
by us.
right.
I think that's Senator Lamb's point.
right, that you don't have to get approved by us. That this is a blanket, this, if we were to pass it, is a blanket green light authorization for all counties to do this, which is very unlike alcohol where we do it one at a time, right? I think that's my concern with how this was.
Look, if I had my way, there wouldn't even be any of these, so
Well,
whatever the will
I
of
would
this
support that
body is.
too, but I have concerns with how this is crafted, but.
Can we not draft it so that it addresses Senator Lamb's concern, so that either that or give the jurisdiction to the locals to say, in other words, in Howard County, if they want to adopt it through their, I was looking at, and the question I was asking yesterday, is there a role for local elected officials as opposed to just the local liquor licensing board? And it sounds like there is not a role for our local elected officials. So then could we be very clear about it requires the approval of a local delegation? In that way, if Prince George's seeks to do this, God bless, they can do it. If Montgomery chooses not to or says, yeah, let's do it, then they can. but at least there's that opportunity to have the input from the local jurisdiction. And I know, I'm not looking to muck things up. I know you've put a lot of time into this. I'm just looking to see if there's still a way, I think, as Senator Lamb has expressed concern, to allow for input in each of the
I have
jurisdictions.
2 comments. One is, that's fine if a county decides not to do it, but what happens to the ones that are already existing there?
Well, perhaps we grandfather, or perhaps they just,
I mean, they still have to have regulations.
or
if
maybe they
haven't
can't
already,
do
for the
it.
ones that are existing.
I mean, we could require them to pass like a local ordinance authorizing it.
To
but-
continue.
Or that, yeah, but this was like the structure of when they did the cocktails to go, this was the structure where it authorized it statewide, and then the individual jurisdictions could decide whether they wanted to adopt it or not. I think the statewide bills aren't that common, and we don't see them as frequently, so that's probably why the structure's a bit different, but otherwise, we would have to put it under Division 2 in every single county that.
What if they were grandfathered in for a finite period of time to allow a local delegation to address existing, and I don't know, I'm just trying to think of what options there may be, so that, they're grandfathered in for 2 years, and if a local delegation chooses to either allow just the existing to continue, then they can take that action, or if they want to expand and allow other licenses, they can take that action. Or if the local delegation says, no, this is not what was ever intended, then it expires in 2 years, and
I don't think you can do that with a business that's already up and operating
you can.
at the direction of the liquor board. That's what happened in Anne Arundel. The liquor board gave them the right under the incidental, and you can't, I don't think you can go back now and take them out of business.
Okay.
Let me see what the vice chair wants to add.
Yeah, no, I just wanted to add to the conversation. I know there's been an extensive amount of work on this, and this product is a work of, a work group, actually. I think a 2-year work group that came up with these recommendations. I get the concern about, like, I think Senator Lamb used the term like a blanket approval. It's not necessarily, I get what you're saying and making that statement, but it is authorizing to let a local body make these decisions on behalf of their county. And most jurisdictions, I don't know what it is in all jurisdictions, but I know in Baltimore City at least, our liquor board is appointed and confirmed by our delegation already. And so the input and feedback from the delegation is already inherent. I'm not sure if that's the case in other counties. But, I think it has been a lot of work that has gone into us. I hear what, I was about to say, Brother Kramer. You are my brother, but I hear what Senator Kramer is saying, and
Just maybe some local autonomy
right.
of some kind.
Yeah.
Senator?
Go ahead. Yep.
Thank you, Madam Chair. I was just gonna, make a suggestion, because I don't know if these cigar lounges, without the liquor, if they're already authorized to as retail establishments within the county, are they already authorized? They can develop anywhere they want?
When we did the Clean Air Act, we exempted premium cigar stores. That's how this kind of started. So
Got it,
no
okay.
one else can smoke indoors except premium cigar stores, and that was a state law.
Got it.
So I guess in their counties, they have to have a retail license, they have to have an occupancy permit, but the liquor board wouldn't be controlling them because they didn't have liquor, we
Yeah,
thought.
My question would be, can the council get involved in authorizing the cigar lounge itself, or the premium cigar wholesale or store itself
They only do that through zoning.
through zoning?
Yeah, it's not through zoning.
I was trying to help out with the
Yeah.
when I
Yeah,
have
the
other
tobacco.
issues.
Senator Lamb, you still have your light on.
Oh, I just never shut it on.
Okay. But you still had something
There
else.
is
to add.
statewide regulation of tobacconists under the business regulation article.
Got it.
Yeah.
That allows them to exist. Mm-hmm. Got it. And they can go anywhere in the state.
Yeah.
Got it.
As long as they follow the zoning laws.
Is there
Fair.
any reason we can't set it up as we have done with the beauty shops, barber shops, nail salons, so that each jurisdiction has the autonomy to decide if this is what they want for their jurisdiction.
I think that's what this does.
Well,
Or that's
It-
what the intent was with, as far as the
I
regulation.
think there seems to be some, at least ambiguity, if not concise, clear language. Could we maybe clarify?
If a county doesn't
Something.
adopt regulations, then they don't have them in their county.
Well, I guess, are you saying you're wanting someone other than the county liquor board to be authorizing these?
Yeah, because again, I'm hoping that maybe we can look at elected officials at the local, either in our, and that's why I, was talking about whether local elected at our council level or even at the delegation level to do something and just clarify it. And that way it's not up to just, and look, I don't know where my liquor board might be. I've never had conversation with them, but just thought maybe a little local autonomy.
Authorized 2 of the 4 they can have, so I'm not too worried about it.
I'm curious to understand why you would want like local elected, because it does put like elected officials in a precarious situation to call balls and strikes or winners and losers as to who should locate a business. Can you just help us understand a little bit more why you want the input of politicals versus like the
Except we're being political right now. We're calling the balls and strikes, and we're throwing those right across the plate and saying, everybody, you can do this. But it seems to me this is the kind of issue, as we do with so much else in the world of alcohol, we let it happen at the local level, and we offer some local autonomy to decide, here's, how we would like to proceed. And it affords every jurisdiction the opportunity to then say, okay, we're good with it, we're comfortable, and we're confident that this will, be okay for public health, as opposed to jurisdictions where maybe, and I'm not saying I know what the outcome will be, I'm just trying, I'd like just to give our local jurisdictions the opportunity to say, kind of like tobacco
right,
at the local level.
right.
Just, again, giving some autonomy to the,
All right, so this is a policy decision for this committee. Do we want everything to come back to the state delegation for approval, or do we want to leave it to the counties to create the county liquor boards to create the regulation? I don't care, but we need to make a decision.
I would go with giving local jurisdictions, local delegations that authority. Are you comfortable with that?
That stays in the counties?
That you all would be, the local delegation.
You'll have a lot of new liquor bills next year, and I won't be here to enjoy it.
Your local delegation, you and your other House and Senate colleagues would
It's unprecedented.
bring in a bill that says
Charity
you
said her
can
and
do
Georgiana
this
say
and
it's
this
okay to
is
put it
how
in
it
there,
is.
but they.
And that's the way we're proposing to handle this?
I think that's the conversation.
And-
Got it right.
And the existing businesses would then have to come in next year to get that approved, or would they be grandfathered?
Can we,
The ones that are doing it now would be
I
grandfathered.
don't see.
Right.
a reason you can't put it in there,
So
but I think
existing would be grandfathered. Going forward, though, just as we do with barber shops, each jurisdiction would be able to come in and say, we would like to provide this in our barber shops. Well, we'd like to be able to provide this in our cigar shops.
Okay.
we're giving them permission to do it if they want to.
Yes, giving the locals permit, yes, permission to do it if they'd like to. Do you agree with that, Senator Lamb? Are you in that? Do we have,
Do you even like the bill?
giving the local delegations, leaving it up to the local delegations to introduce legislation approving it?
Being local state, you mean the state
Correct,
delegation?
local state delegation,
Yeah,
not
local state
local electeds, but
Yeah.
local state
We do
delegation.
the alcohol regulation now.
Right.
We as the state, they don't do it individually. We do it.
I think that's.
She wants me to stop.
I mean, we're saying in here, we're already saying what hours they can serve, we're saying they have to do tips, we're saying that the fee can be between 500 and 2,500. We've already put a lot of guidelines in here. I don't know what else they'd say.
No, I agree, so it's all laid out, the framework is here, now let each local state delegation come in and say, we would like to do this within our jurisdiction. And again, that, I think, addresses the bill sponsor's issues. In his jurisdiction, they can do that, but perhaps in other jurisdictions, there may not be that
I'm
interest.
so confused, because it says in number 2, this section applies only in a jurisdiction in which the local licensing board has adopted regulations to authorize the issuance of a local. This already says it's up to the local liquor board.
And can we not say in which the local state delegation has approved the adopted regulations to authorize?
What's questionable?
And then we're very clear.
If that could constitute a legislative veto in the sense.
Constitutionally questionable.
Because we already are passing a bill that this is allowed, and then we're gonna come back and say, we could veto it.
By less than the
'Cause
full
that's not-
legislative body.
But that's just then the way it's currently worded. But you can reword this bill to state that it is done by, just like we do everything else in alcohol, we would be doing this no differently, would we not, Nathan? Why would what we do now,
I'm trying to read this
But
as I'm
but isn't it
sorry.
also, we already can do that, right? Can't we, like, if we wanted to introduce a bill to allow tobacconists in our district to serve alcohol, we could do that. That's the way it currently is.
No, you can't, because the health department says you can't have indoor
No, but
smoking.
if we as state legislators was to pass a bill for our district or whatever, we could do that because the legislature has that authority.
So I understand Senator Kramer's
I
suggestion to be
understand.
different from that. Senator Kramer is saying that the county would come back to a subset of the General
not the
Assembly.
county, the state delegation? Not the county's out. It's the state delegation.
The county would come to the state delegation to say, we are seeking to adopt regulations to allow this license in the county, correct? Under your hypothetical.
Well, we could allow this bill to be the regulations or say, yes, that the local jurisdiction, the local licensing board can adopt regulations with the approval of the state delegation.
Okay.
Or
Yeah.
however it would be appropriately
So
worded.
thank you for restating that. So citing from the legislative drafting manual on the subject of a legislative veto, it said, the rule is that legislative oversight of executive action outside the passage of legislation is constitutionally questionable. To determine whether a legislative action undertaken by less than the full General Assembly, which is what you're contemplating by talking about approaching the delegation from the county for this approval, to determine whether a legislative action undertaken by less than the full General Assembly constitutes an unconstitutional veto of an executive action, a court will have to weigh the scope and duration of the interference with the core executive function caused by the legislative action. So
then, Nathan, is the approval of each of the barber shops and the beauty salons questionable?
no, because the legislature is passing a bill that authorizes the county to do the thing. There is no process for the county to come back to the legislative delegation.
The exact same thing with
Yep.
this.
And so to describe how that would work in this bill, it would be if authorized by statute, if the county is specifically authorized by statute to have this type of license, then the process laid out in the bill could take place. What has been being discussed is for the bill to be silent as to which jurisdictions may offer this license, allow the counties to adopt their own regulations, and then return to a subset of the General Assembly for approval. That is a process which is dangerously close to a legislative veto.
All I am asking is, and Senator Lamb, I believe, was in the same place, why can we not do what we are already doing all the time and follow that?
Nathan has answered your question. You just don't like the answer.
No, it's,
There is a way.
no, actually, Madam Chair, I disagree wholeheartedly in that he is
They
saying
could turn this into a
that
county
I have,
bill if they want it.
Nathan is saying that what I'm suggesting is not going to work.
Right.
So all I'm saying is, we have something that does work.
Yeah.
If that's what it takes, do that.
Okay.
I'm not saying I've got the right language for it to be constitutional or appropriate. I'm saying there is a current process. Adopt the same process. That's all. And I think, I don't want to speak for Senator Lamb. I believe he had the same thought, but
Yes,
Wow.
the process was the same thought, but I have a question to kind of follow up on what Senator Kramer was saying. The version yesterday did not have this paragraph 2. Not having,
Paragraph 2, which one?
On page 2.
Yeah, there were some provisions added in to the reprint since last night, and that was one of them to try to clear up that confusion about whether they had to come back here or not to
but
enact it.
my understanding was that without this provision, the way it was yesterday, without paragraph 2, it says that it's subject to Division 2 of this article. Division 2 of this article, I think, puts it back in a posture where the local jurisdictions do need, just like we handle alcohol, they do need the General Assembly's approval to this. And maybe you can clarify, doesn't the Division 2 language mean that there needs to be authority specific to a county in Division 2?
So that language was requested, and we weren't totally sure what it meant, and it was despite explaining that that did have the consequence of possibly requiring them to come back and enact it for each county. The sponsor for this was the House sponsor, I guess, still wanted in the bill. I don't know if we want to defer to the advocate to explain why that was asked to be put in there. He's here.
Before we do that.
Because I thought
Matt,
if,
I think you're going to need to come up to the table, but not yet.
if,
Senator Lamb, if I can have two
Sure.
senators that haven't spoken yet. Senator Mounts, since you have some involvement in this kind of work, what
Well, this, I'm trying to understand kind of like what we're talking about. So the idea that what's proposed in the bill is that we pass this bill and the counties adopt regulations if they want to have this business in their county, right? Isn't that the way this is
yes,
proposed?
right?
With the amendment,
Yeah.
the most recent version of the amendment, yes.
But we're discussing about, we are just debating right now additional steps in addition to what's proposed in the bill.
They wouldn't actually be able to issue a license, that we'd have to come back to the delegation with the regulation, and the delegation would vote up or down if
Yeah,
they
I-
agreed with the regulation.
I just
right?
have,
Except that might be a legislative veto.
Well, I understand, because this isn't the same as, we're making a statewide statement here when we say they can have premium cigars and alcohol. That's statewide. This isn't a county by county. They want to serve beer in a liquor, in a barber shop. That comes in county by county. This is a statewide bill, which then would require local regulation. Might be the hours they operate, I think, or it could be, whatever other regulations they make.
the bill also contains certain requirements on how that business can operate. So it's not
Some
like,
things.
it's not basically counties, you can just go ahead and license this. Just-
Right.
If you decide you want to do this, you can do this following A, B, C, and D. And
Yeah.
that's how it can
That's
operate.
correct. It's setting like limitations. So the county couldn't come in and saying, we're going to give 4 for every 150,000 residents, but they could say that they can only operate from like 12 PM to 6 PM or something.
And so it seems like this concern is that, well, we want to have another review, like, so the county makes the effort to implement the regulations. And then now we're debating on whether we want them then to come back after they put the regulations in to get another
And
approval.
that's what Nathan's having the problem with. That's where he thinks it's a.
Oh, yeah, that's where the
What did you
constitutional
call it?
issues
Is
come
it
in.
Legislative veto.
Legislative veto. That's
Right.
what he's concerned about.
Thank you.
Senator Jackson?
Lisa, the amendments we spoke about, is that in here?
Yeah, so Senator Jackson did have some concerns about the licenses applying to local jurisdictions that already had a cap in place for total liquor bills. So first, we think that regulation would apply to, because they could incorporate their license cap, this into the CPCL license into their license caps they have. And also on the last page of the bill, there was uncodified language specifying that, oh no, you're right, I meant to put the language, I apologize, about that should count towards the total number of licenses allowed in the jurisdiction as well as the CPCL licenses. So I apologize for that, I can add that in there. if
So,
that's-
just so I understand, because I know Anne Arundel already has two, with the population limit in Anne Arundel, they could have 4. So the 2 that are there already count, and they can only have 2 more. They can't have 4 more because of the bill. That's what we're trying to say.
Yes,
The total is the total.
yes. But I mean, if we did make that one change, that would address the concerns. Okay, sorry.
Okay. Senator Reedy, you're next.
I just want to say, first of all, I'm okay with the bill before we make any more changes. I think we should, I think this has been too long debated. I don't know that we ever should have put the moratorium in to begin with, but I understand why it happened and all that. Needed some opportunity to regulate it better. I understand now better with the legislative veto thing. It was just explanation. I guess I'm wondering if Senator Kramer's, and the point he might be making is basically like, you know, with alcohol, we have to come back and make changes in our local counties. And I think the desire is to set up some structure where now you come to get for this, the same thing we do when we change our local alcohol laws. It is true, though, that we've set a statewide framework for alcohol. I can't come back and say, you know, I can't allow somebody in my county to do something that's not allowed by the overall state framework. So I was going to ask, why is that different? But I think I understand now. We're saying, here's our framework, here's what you can do. But now we're going to say, but if you do it, we can still veto it or something, that's generally what you're concerned about from a constitutional veto standpoint.
By less than the full General Assembly. That's the point, is that the discussion that was before the committee was that veto would be by less than the full General Assembly. I want to be absolutely clear that there is a way to accomplish what I understand Senator Kramer is talking about conceptually, but that we don't have that in writing, and it would.
But would that,
Can you generally explain it, and then we can.
would that way be setting up a structure like we do for alcohol?
So I guess the structure of the alcoholic beverages article, or alcoholic beverages and cannabis, is there's Division 1, which applies statewide, and then there's Division 2, which has a section for every single county. And so the statewide ones would apply to everyone, and then each county can decide, do we want to adopt the statewide one? Do we want to not adopt the statewide one? Or do we want to adopt it with some variation in it? So we could amend the bill so that this was put instead of Division 1 in the statewide bill, every single individual county had a provision about this, in Division 2, or the ones that wanted it have it, and the ones that don't have it.
What I want to do is pass something like that, and then it mean that the people who are currently operating now have to wait for a county delegation bill to come through the next General Assembly, right? So that's the other concern, I
Well,
suppose.
that could still have the uncodified
Or they'd be
language.
grandfathered.
Converting the licenses, that wouldn't be an issue to include.
Too many discussions.
I'll
All right, so
I
we
will
can do
yield
that
back
by
the balance.
uncodified language.
Okay, great, good to know. That's fine.
Senator Lamb?
Yeah, I think I think this is what Senator Reed was trying to get at, but like I mean, we're going back to the difference between Division 1, Division 2. This language in paragraph A1 was added in saying subject to Division 2 of this article, which my interpretation originally was that meant that counties had to opt in to it, right? Is that your interpretation? Because why was this line added in? It was added in for a specific reason. I think we've had some conversations with Calvin over in drafting to understand what this line actually does, but this was not in the original. This was added in at some point in time.
Yes.
What does this line do?
Okay. do you want to, Matt?
If I may, that line, that amendment was added. This language or concept this was per the Licensed Beverage Association. They were favorable with amendment on this, not this exact language. I think the intent trying to be captured here was that any of the local laws, rules, regs, as it pertains to liquor licenses being issued would have to be followed.
That doesn't answer my question.
So-
So what exactly, from council's point of view, does paragraph 1 mean or do? Because my understanding from Calvin is that, who's in drafting, that this line basically requires jurisdictions to opt in. So
That was how Calvin and I read that provision when it was requested. Calvin, this came in as a request to the House sponsor. I believe Calvin explained that to the House sponsor, but the House sponsor still wanted it. I can't speak for that, but I know that was how he and I interpreted it, but it was still requested to be included in the bill. So
So what is your interpretation of when it says subject to Division 2 of this article mean?
I read that as ambiguous, but potentially requiring them to put every single enacted under Division 2 if they do wish to enact these in the specific
To
jurisdictions.
opt, for local jurisdictions to opt into this?
Yes.
But then paragraph 2, I guess, blankets everyone in, and the intention, I don't think the intention of Senator Kramer was to do a legislative veto. I don't think we're not saying that we want them to come back. What we're saying is that we don't want them to do this unless they have the authority subject to Division 2, which was the original language before today. I think paragraph 2 is problematic to what I think.
Can we go through the rest of the bill and look at the requirements, and we'll come back and talk about whether or not there's enough in the bill? Because there's a lot. They can't have entertainment, they can't have a commercial kitchen, they have hours of operation, they have their range of what their fee can be. I mean, we've done a lot from a statewide standpoint. I'm not even sure what's left for the locals to do other than decide about location. And even that, they can't be within
Right,
5
but-
miles of each other.
But
and
the
they
way
can't be
this is
within-
drafted, it is treated differently than alcohol, where you don't need a local bill to opt in. I think that's what we were trying to get at. I think that's where I've discomfort without having a local bill or local delegation approving to opt into this. I'm fine with grandfathering the ones. I'm not saying that the ones that exist can't exist. But
They have to adopt regulation to authorize it. Why is that not an opportunity to opt out if they don't want to?
that's for the local
Right.
local board.
The
I'm
local-
saying
The local licensing board can adopt regulation to authorize the issuance, and if they don't, then they're not authorizing it.
I mean, would it be better if we struck or amended the language in A1 to be clear that that's not subjecting it to Division 2? Or maybe that is what you're wanting to do?
No, I do want to
Okay.
keep subject to
Okay.
Division 2.
I guess
because
it's more
think-
of a debate about whether these are authorized by regulations by the localities, if they're authorized by the delegations by statute, or if this just authorizes them as soon as the bill is put out, is the issue right now.
Well said.
But I guess even if you were to keep paragraph 2 in, it's still subject to Division 2, right, in paragraph 1?
I mean, they would have
This
to.
whole section is still subject to Division 2.
In the sense that it can't conflict with it, I guess. Under the normal rules of interpretation, Division 2 conflicts if Division 2 controls if Division 1 conflicts with it. But, I mean, if we took out A1, they would be allowed to issue the laws as soon as, if they adopted regulations or issue the licenses.
I would not want to take out A1.
Okay.
But I think A1,
Yeah. No, if you were wanting them to be subject to Division 2, I would probably put in a bit more language to clarify that, but A1 would stay in and you would remove A2.
you think there needs to be more clarifying language to clarify that they are subject to Division 2?
Well, I guess it's kind of unclear what subject to Division 2 means. I guess if Matt was saying it was trying to mean they were complying with all the other provisions of the alcoholic beverages article, but if they're subject to Division 2 in the sense that they need to enact legislation under Division 2 in order to issue a license, I think there might need to be more language to clarify that that was what that is referring to.
I mean, I think that's what Senator Kramer and I were getting at, that latter option that you just described is probably what would make us most comfortable. Right, Senator Kramer? Yeah. I think this interpretation could get to what you're saying. It may be a little gray, but I think to your point, we would be more comfortable with that more clearly articulated out the way you just did at the end there.
And I'm concerned when council says that something is ambiguous right out of the gate. And I don't think that's the way we should be legislating, is if there's already concerns about ambiguity and interpretation. So just putting that out there, but I agree with what Senator Lamb is just saying. I don't care how we get there. The point is, I think that's appropriate, so.
And I think we could get there by the phraseology that you just used there at the end, clarifying what subject to Division 2 means.
Do you want me to go through the rest of the amendments, or and then we can go back to the issue of whether this is legislative,
Well,
regulatory?
no matter what, we hold the bill for an amendment, so.
Should we just wait to go through the rest of it tomorrow then? or-
Let's go through the rest of it.
Okay,
We've
the-
got time. We're not going to
Okay.
for now. Let's go through the rest of the bill. We'll come back. We'll hold it, come back tomorrow with another attempt at an amendment, I guess.
Okay. So to go to the next page, we had, yesterday, the commercial kitchen amendment was in there. Here's the language that Senator Jackson was looking for, that added that the issuance of a Class C PCL license is subject to local regulations regarding the total number of alcoholic beverages licenses that may be issued in a single jurisdiction. So that says that, so we added in language saying subject to subparagraph 4 in the lead-in, so that clarifies that this is not a numbered page, it's the page after page 2.
Top of the page is partially blank at the bottom.
Yeah, there's half a blank page. And so, yeah, that was the added language since yesterday, was clarifying that the cap applied to, in counties where there was a cap on total amounts of alcoholic beverages licenses. On the next page, there was language added in these, this was from Senator Lamb's amendment, that specified that an employee sign an acknowledgement about exposure to secondhand smoke is not waiving their rights. And then there are additional provisions at the bottom that were added in from Senator Lamb's amendment that prohibited an individual under the age of 21 from being on the licensed premises. And then the chair had also put an amendment asking that live entertainment was not allowed on the premises. On the next,
Where's that?
that's on the very bottom of page 3.
Okay, thank you.
And then on the next page, there's the similar provision about BY only is only authorized in jurisdictions in which the local licensing board authorizes this. Obviously, if we're amending the bill, as discussed, that would also be changed. And I believe the only other changes are on the page that says page 505 at the top. Added in the provisions from Senator Lamb's amendment that credited the taxes from the sale of alcoholic beverages of a holder of a Class C PCL license to be credited to the Cigarette Restitution Fund. And then at the end,
Senator Lamb wants to comment on that.
yes,
You could delete that.
sure.
Okay.
That's not in there
We'll just
anymore.
remove
And then at the very end, on the last page, in the uncodified language, in paragraph A, we added language at the end clarifying that the licenses that are converted could exceed the license caps. But then at that point, those licenses would be counted against the total. So if a county is allowed to have 2, they convert 4, 3 of those businesses would have to close before they could issue a new license, if that makes sense. And then I put in clarifying language stating that this counted towards the total number of Class C PCL licenses allowed in a single jurisdiction. I think it had said, we can change it to say total as well if we wanted to clarify that as well. And those were all the changes from yesterday.
Senator Lamb, did you find out if Howard County has BYO with,
We asked, I haven't heard back yet.
just curious.
I have a different,
Yes.
Good.
Lisa
Senator
didn't,
Washington, go ahead.
yeah, she didn't go over my amendment.
Oh, I'm sorry. And then we have Senator Washington's amendment that was, came in late, so we did not have this incorporated in the reprint. However, it does work with all the other amendments. Although I'm guessing if we're amending the bill to be local jurisdictions, we would tweak the language somehow. But this is specifying when the local jurisdictions are enacting regulations, what they should consider when they're issuing the license, and list certain factors for that. Those are on the second half of the second page of that, saying that they need to establish a scoring or weighted review process for the license applicants that considers minority business enterprise participation if they qualify as a social equity applicant. These were all taken from the social equity provisions under the cannabis article.
This doesn't mandate that they have to give these to these individuals. It just says that they shall consider these as qualifiers.
So would that be like if they had two people applying, they should consider the social equity?
They consider whatever they want in this list.
But you're just asking them to consider it?
Correct, exactly.
Thank you. Senator Land?
Thank you, Madam Chair. So a question for, I guess, for council. Obviously the intention of this bill is to track these cigar bars towards the CPL licenses that we're creating in order to be able to sell alcohol, right? If these cigar bars want to sell alcohol, we're trying to steer them towards these CPL licenses. I guess it was flagged to me just very briefly before this that there isn't any language in this bill stating that a tobacconist cannot sell alcohol under a different local license. So, a local liquor board could have a different license to be able to give to these tobacconists. So is there some ability to include language in here where appropriate, something along the lines of like a tobacconist is not permitted to sell alcohol unless they hold a C-CPL license, just to make it super clear that the local board cannot just give them a different alcohol license?
Yeah, I think was the issue that originally it's a Clean Indoor Air Act violation if they had a liquor license. So I think technically that prohibits it, but I don't think there'd be a problem with clarifying that, like, no, you cannot have an additional license
Right,
because they might not be aware of the requirements.
It has to be a CCPL license.
Yeah, we can put that in there.
Okay, all right.
All right, so we have to resolve this one last amendment. Senator Reedy.
Can I ask, one thing going the other way as I've been looking through all this, I noticed the population limits in the bill. So for example, in Carroll County, I don't know that we would have a bunch of these, but basically in a very, very large geographic county with a decent amount of population, I've got like 180,000 people, and I'm going to have multiple cigar places that would have to compete for one license. So I kind of don't like it the other direction. Obviously, the way the makeup of this body, I'm not sure I'm going to have much luck here, but I think I don't mind the 5 mile limit. I think that makes sense not to have a bunch of these, but to
You have 180,000 people.
yeah, give or take.
You
Yeah,
would have one license.
yeah. And is the next one up 250? Is that what it is in the bill that you can get?
No, it's one for every 150. So that's
Yeah.
all, one for every 150. So in my county, I have less than 600,000. So we would have 3 licenses. Now, it's a big county,
Yeah.
geographically, it's a big county population-wise. We already have 2 operating, so really be competing for the 3rd one. And it could just be anywhere within, just so it's not within 5 miles of the existing 2. Look, these were never supposed to happen.
So now we're trying to find an answer
The Clean Air
for.
Act said
Yeah.
you don't smoke and drink in the same premises. So we're doing something to kind of protect the businesses that slip through by local liquor laws without proliferating them all over the state. That's the whole goal. Senator Matz?
Madam Chair, I think you just
Such a
answered
bad
my
law,
question.
that thing we're at.
I hadn't thought about that aspect, but I was just going to share with everybody, I represent 4 counties. You look at the numbers. It takes an hour and a half to drive from one end to the other.
Well, see, in my traffic, it takes me that long.
Well,
So
but I
let's
was-
talk about your county, Senator Mouth. So Queen Anne County isn't yours, that's Senator Hershey.
We've got all of Talbot, all of Dorchester County, most of Caroline County, and half of Wacomico
So what's your
County.
population in each county?
So you got 39 in Talbot,
So they'd get one.
and then you have about 34 in Dorchester. I'm just speaking off the cuff.
All right, that's okay.
Yeah,
Less
and
than-
then-
But less than 150.
Right, oh, yeah.
So you get one.
And then you get Caroline, and that's only part of Caroline, so you're about another, 31 total in the whole county, and we only got part of that. And then you jump to Wacomico County, which bumps up over 100,000 people, and we have about half of that county.
So you'd have one in each of your counties, and that's all you'd have.
Okay, all right. That,
Change it to what?
No less than 2. Because then you have just one that's in the whole county. That's an unfair competitive advantage if you have just.
Yeah, and I've got the same as Dorchester.
Oh, my.
We did that on another.
No offense to Dorchester, my wonderful friends in Dorchester. I just mean Carroll County's got 5 times the number of people.
Yeah, we did that on another liquor bill with Cecil County. That's why I remembered it. When we
Oh,
did
man.
by-electric.
Matt, I've been.
What did you do?
I think I
With another bill in Cecil County with we did it, one license per every, I think it was 3,000 voters.
Yeah, we can hold the last one.
Or 20,000, but no less than 2 licenses per,
Oh, good, we just doubled it. Okay, no less than 2.
no less than 2. I like that.
No less than 2 per county?
Oh, no, I'm not doing that.
Why? What's wrong with that? I just figured you had those big counties and you get to have 4 or 5 of them.
You get a whole bunch. You get
Yeah,
like
but the
one
whole
per
point
every
was that
20,000 people then. You get like a better.
The electoral
ratio.
college for cigar bars.
What?
Just no less than 2.
So basically somebody that's 150,000 people then? What is it?
Yeah, they would.
So we get 3 in our whole county, and he's gonna get 2 in little itty bitty.
You're fighting for them. You know that they're popular. and you wanna
It's like
get
the
one.
United States Senate, but for cigar bars.
There you go.
Under the age of 30 smoke cigars.
Exactly.
Smoke cigars under the age of 30.
I love that, I love it. Senator Kramer?
All of this goes to the point I was trying to make earlier, that perhaps in a jurisdiction where all of those who don't have this license will now be put at a distinct disadvantage because one will, then perhaps the jurisdiction should have the authority to decide at their level, do we want to do that? And if so, God bless. And if they determine we don't want to put everybody else out of business because this one license is going to put all the others at a competitive disadvantage, then let them make that decision at the local level.
You are now promoting more indoor smoking, which you didn't like
I'm
the bill to
not.
begin with.
How
So-
am I, why are you under
Because
the
you're-
impression I am?
Because you're saying basically leave it up to the local jurisdictions and don't protect just one.
And do what?
And you're saying don't have just one because that's an unfair disadvantage, so how many do
No,
you
I'm
want?
saying have none, and then you don't have any at a disadvantage. My point is being,
God.
they could decide,
That's socialism right there. Everybody.
Matt, can you tell us what's happening in the House? At one point, they didn't want to do anything but grandfather the existing. What's going on in the House now?
It has not moved in the House as of yet.
So it hasn't moved. So we could be doing all this work and we could have a problem in the House.
My understanding is they're waiting to see what the Senate produces.
Okay. Yeah. I don't know. Do we want to ask Nathan and Lisa to come up with a different amendment on how the local liquor board will respond? Do we want to ask Lisa to come up?
So are we putting in the requirements of the bill as amended, but then making it so each jurisdiction has to enact legislation to authorize this, is what we're
But
hoping to do?
that's what you're concerned about with, no, that's okay.
No, he was concerned about the regulations.
Okay. Okay.
Yeah. Cool, okay. Yeah, so then it would be, each county has to come back and adopt legislation if they want to do this, and the legislation would have to be in line with the overarching requirements of the statewide bill.
Is that what you all want?
I don't know. I was told it can't be done.
No, they're wording it different.
What we couldn't do was we couldn't have the delegation approve it, adopt regulations, and then the delegation can say yes or no to the regulations. We can adopt the bill, and then the delegation can say yes or no to adopting their own county bill for that. I guess the distinction is whether they're adopting a law or regulation.
But they still could come back and say, we don't want any more in our county.
Well, we could say that we don't want any in our county. We don't have.
Right.
But they would still be, we'd still have the provision about converting existing licenses, so they.
Grandfathering the current ones.
Okay,
I'm
so the
not
county
trying
would
to
still
kill
have them to the extent that they already exist, but they wouldn't be
Yeah.
issuing new ones. Okay.
Yeah. But if there's a county that has never had them.
Yeah.
And the county chooses not to enact legislation to allow them.
Then they would not be allowed to have them.
Correct.
Yeah.
Okay. And you can do that legally? Okay. All right, got that. We'll have an amendment tomorrow. So I just
Yeah,
held the bill.
Can you say it one more time now that you,
So,
listen up, Jackson.
not indoors. So, the bill, we are amending the bill so that the bill would require, the bill as passed would set up a statewide regulatory scheme and requirements for the CPCL licenses. And then each individual county's delegation would have to come back and enact a statute on their own for that county if they wanted to establish this type of license for the county.
Sure, why not?
And grandfather
And the existing licenses would be converted still,
So, we'll
potentially. 23 maybe.
Because they actually have veto authority in the delegations. I mean, essentially, if your county came to delegation, Montgomery County delegation said, can we put this bill through? Then the delegation votes, and they could say no.
Right, but it still has an opportunity to come to the larger body.
How?
Versus, because if they say no, yeah, they.
Well, that's what Nathan was talking about earlier, is having that.
That was the issue with adopted regulations, not a law. So if the board adopts regulation, or the liquor board's like, hey, we adopted these regulations, we voted them up, delegation, what do you think? A delegation says no, that's them shooting down something that they'd
Okay,
adopted.
so
But
just the
if,
delegation.
but if
just
we're
the
off-
regulations.
yeah, because they're the regulations that the board adopted. But if the legislature is authorizing that the counties can adopt these licenses, the counties come back and act a statute, that's not the same thing as we've adopted a regulation that you guys are now shooting down.
All right, I'll buy that. Thank you. Oh, he was first, I'm sorry.
I was gonna bring up a different issue.
Okay, let's let Senator Reedy count on this.
Down, because I also, if a county said, hey, we do want this, but we only want it to go to an existing cigar license holder, so that we don't have somebody come in, try to do this.
We don't want any new ones.
We don't want investors, like, we don't want like new investors trying to come in and buy up a license. That, they could also do that if we passed it with your language, if we made, not your language, but the language you're talking about, it would give a county the ability to say, we either don't want it, or we do want it, but we want to say, hey, we only want to offer it to the people who already have a cigar shop in our county. We don't want to or whatever, or not. Or they say, oh, we want to throw it open. All fair, correct, if we did it that way?
Well, currently, if we kept the uncodified language, that would just convert the licenses regardless of how we change the function of the bill to apply to the single jurisdiction or the statewide or anything. So they would still be converted, and then if the jurisdiction didn't adopt any further law, they would just have the converted licenses and nothing else.
But if you had a county that didn't have any of this in it,
They would have converted licenses and nothing else.
But you'd have the opportunity.
You'd have the option.
To determine how it would work within your.
right, so you could limit it and say, I don't want somebody new coming in to get I got it. The county would have the regulatory authority. Okay, thank you.
Senator Mouse?
So would it be okay to bring up a different issue right now, or do you want to continue discussing that?
In the same bill?
Yeah, in the same bill.
Okay, go ahead.
So I opened up, I proposed a restriction yesterday dealing with live entertainment, because I'm intimately intimately aware of a lot of the dynamics. What I did not realize when I said that, because I'm not a frequenter to these establishments, is that they will have like promotional things that go on. And a blanket, I'm concerned that a blanket ban on entertainment may actually prohibit things from going on that currently go on. One thing that was suggested to me was like a speaker on a topic or something of that nature,
I don't think a speaker is entertainment.
or a comedian.
That's entertainment.
That'd be entertainment. I know I talked to the Beverage License Association about this, and the concern was more about live music. And I'd roll back my comments yesterday to recommend prohibiting live music, and then leveling that restriction would be enough to keep it from getting out of control. And that's after a phone call that I made today, rather than just say live entertainment.
You know what, right now in your county, well, at least in my county, because you have a liquor license, if you want live music, you apply for a different license. If you want dancing, you apply for a different license. Entertainment requires different licenses in our county. I personally, and you all can take a vote, but I personally don't think we should be adding entertainment, because these were not meant to be places where people hang out like in a tavern.
Right.
You go in and you have your premium cigar and you have your nice shot of bourbon or whatever you're gonna have, but you're not gonna be spending the evening in a room full of smoke,
Right.
my opinion.
And I understand that. I didn't realize that this was already going on.
Well, it's
Because
not
we were-
gonna continue to go on because they don't have a license to operate.
Right, right.
Senator Jackson, did you have anything else?
Oh, yes, yes.
Okay. Okay, that's going to end the discussion on 623 until tomorrow. It's on hold. We have one more bill, Senator Washington's bill, Senate Bill 866. This is the one with restaurants adding sodium and sugar icons, and, Lisa?
Okay, so we do have a different amendment. I know we held the bill from Senator Mouts, requested by the Restaurant Association. So you have a reprint in front of you that is missing a provision, so I will add that in verbally. But what the reprint does is it makes it so that a chain restaurant, instead of having to display an icon and instead of having to display that text on the menu, it says now instead that a restaurant has to make the full nutritional information available through a QR code, their website, or in a printed format, and then display on the menu board. If you flip to the last page, a written disclosure notifying customers that standard menu items may contain high sodium or high added sugar, and full nutritional information is available through the QR code online or on request. I did miss the provision of the amendment that added a fine not exceeding $500 for the first offense and not exceeding $1,000 for a subsequent offense within the same year that was intended to be added to this.
Accept this amendment. This is an amendment that guts the bill essentially and changes it to a QR code instead of like a icon, which is what the intention of this bill is. And so I rejected the amendment. I think it's just not something that we should consider as a committee, because the idea is, if there's a senior that goes into that has diabetes or whatever and goes into a shop, they might not have the ability to scan a QR code. But they will be able to see that icon that's on there. That'll be beneficial to them. So I just reject this amendment and ask the committee to reject this amendment so I can plan for the floor debate.
Thank you, Senator. Does anybody want to move a motion favorable in a second and watch it go up in flames, or what?
On the amendment?
When you put it that way.
Yeah.
Move the amendment unfavorable.
Oh, move it unfavorable, okay.
No, the amendment.
Yeah, that's what he said. He's moving the amendment unfavorable. Okay.
I can withdraw.
Senator,
So we don't have to go through that. If I'm the one proposing, I can withdraw it to save it, so you can vote the bill. But I wanted to give at least the opportunity for the committee to hear the amendment and evaluate the amendment.
You fought so hard for it. Thank you. Appreciate that. Let's go.
Okay. You move the bills,
amended by his amendment.
Just so I understand, I remember what this was, like, this was a link, right? This is not the icon, because I remember we discussed it yesterday, and that's what, we removed the QR code,
So.
What does it do now?
So, well, that amendment with the QR code was just
Right.
withdrawn, but so the one as amended by Senator Washington's amendment, that one, it does direct people to the chain store's website, but it still has the icon next to the individual menu items for the high sugar or high sodium, and then has the notice once on the menu saying that warning, these high sodium and high sugar items can be bad for you.
You know how you see the little icon that says it's the pepper, that it's hot, or it's the gluten-free?
Oh, sure.
This would be a little icon for high sodium, a little icon for high sugar.
Okay, all right.
That's
Thank
all.
you.
Okay, so we have a motion and a second on the bill with the sponsor's amendment, Senate Bill 866.
I'll second
Who was the first? Was it Senator Washington?
Washington.
Okay. Okay, so can we take a roll call vote?
Do we, Senator Reedy, do you want to, does he want to speak?
Sorry, I was just going to explain my vote.
Okay. Senate Bill 866, favorable with amendment. Vice Chair Hayes?
Yes.
Yes. Senator Kramer?
Yes.
Yes. Senator Reedy?
No, and just explaining my vote quickly, we keep adding and adding more and more regulations to businesses. And I know these are chains, so it's easy to say it's a big chain or whatever. It may seem like a little thing, but it's just another thing. So that's why I'm voting no. Thank you.
Senator Mouse?
Senator Mounts?
No.
No. Senator Jackson? Yes. Senator Washington?
Yes.
Yes. Senator Guile?
I'm a yes, but I just wanted to correct the record. The fettuccine Alfredo at Cheesecake Factory is only 2,000 calories. So just don't want to be disparaging to Cheesecake Factory more than I already was.
All
Thank you.
right, thank you.
Senator Lamb?
I felt all of those 2,000 calories.
Senator Lamb?
Senator Lamb? Yes. Senator Hershey?
No.
No. Madam Chair?
Yes.
Yes. 7-3, the bill passes.
That's a little diametric from worrying about obesity to not wanting.
Yeah. I'm much better at
So that ends the voting lesson today. Stay tuned for the time tomorrow.